Lord. I've reviewed my notes and I'm content to leave my submissions there, subject to any.
Very good. Thank you. So, Mr. Cousins, we would be grateful if you could concentrate your submissions on the case that emerged towards the end of Mr. Brown's submissions to us.
Certainly.
Which, as you will have heard, focuses upon the AP1.
Yes. My Lord, I will gladly do that. I hope the court will understand that because of the importance of that issue, I am going to have to go into some other aspects of background, because I'm going to submit that a lot of the background here feeds into the question of whether or not that particular feature that my Lord has just identified in the overall context actually does give rise to a duty. And so I'm going to trespass away from that laser-focused point slightly more, or rather more broadly, if I may.
Indeed.
And I'd like, if I may, to start with this important, I submit, very important point of background. That a difficulty in this case has been to achieve the kind of focus that perhaps eventually has been achieved this morning upon what is the complaint. Because we submit it is very unfair only at this extraordinarily late stage for that amount of focus to come on to one point which has not previously really attracted any attention at all. This case has been running for some 6+ years. Well, the facts arose much earlier, of course, but the litigation got underway in 2016. The case was fully pleaded out, and a summary judgment application came on in 2019. My Lords will appreciate from the analysis of the pleadings conducted this morning that absolutely nothing was said in the original particulars of claim, or indeed in the amended particulars of claim, about the AP form. The case was the subject of an application for summary judgment initially before Master Clerk. That was heard in May of 2019. She identified weaknesses in the pleading, and indeed the absence of any evidence over and above the statement of truth signed by a solicitor in the particulars of claim. At that time, the application went part heard. Unfortunately, she became unwell and came 7 months later, before Deputy Master Lloyd. At that time, and this is significant, no further evidence at all emerged on the claimant's part. Although all of the weaknesses and gaps in that evidence had been pinpointed and identified at the hearing in May, still no further evidence was forthcoming to address them. There was, however, in the interim between those two applications for summary judgment, the important development which we have mentioned in our written submission, and you now have looked at more fully this morning, of the re-amended particulars of claim. Now, when that document was sent, perhaps not served technically, when it was sent, and my instructing solicitors were asked to agree to it, it was pointed out expressly to the solicitors for the claimant that if the pleading were amended in the form in which it had been sent, the claimant might as well go away, because the re-amended pleading was totally destructive of the claimant's case. It asserted, and I can take my Lords to it if my Lords wish to go to the passage, it asserted unequivocally that the mortgage had been redeemed with the monies provided by the bank. Now, of course, one follows that through. If the mortgage has been redeemed, it means the monies have been received by the solicitor acting for the claimant, who has then applied those monies in redemption of the mortgage. Ergo, the claimant has received full payment due under the contract, and there can be no possibility of an unpaid vendor's lien, which is the centrepiece of the claim for loss and damage. By the time the case came on before Deputy Master Lloyd, the position of the claimant had moved, so that the Deputy Master was not asked, as we were told he was going to be, to grant an order for amendment at all. It was ambiguous throughout the hearing before the Deputy Master precisely what the status of the re-amended pleading was, but it wasn't actually formally the subject of amendment. Now, by the time we got before Mr. Justice Edwin Gardner, the situation was that the defendants were crying out to know, what is the position on this document? Is this your case or is it not your case? And of course the judge needed to know as well. And the position emerged in the course of the hearing that no, the re-amended pleading was not actually going to be the subject of an application to amend, and it was no longer being said that yes, definitely it is the position that there has been redemption, and none of the amended particulars of negligence were ever actually formulated into particulars of negligence that were pleaded in the case against Rhys Page. Interestingly, at no stage has it ever been pleaded in a draft or otherwise, or set out in a skeleton argument, that the alleged breach of duty consisted of a duty of care which was created upon the completion of the AP form. That is not to be found anywhere. It follows, of course, that when Mr. Kilvert's evidence was produced, Mr. Kilvert hadn't condescended to deal with any such allegation. And he was perhaps deprived by that of the opportunity in his witness statement to draw attention to a part of the form to which you have been taken, but there is one important respect in which that is which has been overlooked. It's page 270 in the supplemental bundle.
270.
270. Or the very page. My apologies, I think I may have the wrong reference there. I'll ask Mr. Dodge if he can.
I think you mean page 303.
I'm very grateful. It is indeed. Further down the page, my lords will see that what is said about FLP is that FLP, the solicitors were formerly FLP, now intervened, subsequently Rhys Page.
But that's in relation to Bank of Scotland.
Well, my lord, that's a completely fair point. But if FLP have been intervened, they must have been intervened in relation to Mr Ul Haq as well. So it's an intervened firm that's identified as having acted for Mr Ul Haq.
Well, I take your point that in relation to Bank of Scotland it says brackets now intervened.
Yes.
But what submission are you advancing based on that?
Well, my lord, this. First of all, it indicates that it's not a current solicitor. But there is another important point. So in other words, it was speaking to the past. But there is actually another important point about this, and it's something which comes out of what my friend says.
I'm sorry, before you go on, is it your submission that the land registry appreciated that?
No, we don't know.
Because if they had appreciated that, surely they would have been bound to say, you haven't filled in box 3.1 correctly because you have not filled in anybody who is currently a solicitor or license conveyor.
My lord, that does go to the question as to what this form in these circumstances is actually trying to detect. Because this case is an unusual one in this sense. Normally, this sort of form will be filled in and sent to the land registry very close in time to the execution of the document, because most people want to get on and get registered. Here, we were dealing with a replacement document, because on Mr Kilvert's analysis, this is paragraph 23 in his witness statement. What he says, he thought that the contracts had been exchanged, but the contract was never formally completed in the sense of registration, or the conveyance was never formally completed by registration. But it's significant it was called a replacement transfer, because he was working on the basis that completion may have taken place at the time, but the formalities weren't properly observed.
Well, is that strictly correct? He certainly thought contracts had been exchanged,
Yes.
but he'd been sent a TR1 which was not witnessed. And so there had not been effective completion, let alone registration.
My lord, that is dissecting it in stages. Money had certainly reached FLP from the bank. Whether or not completion of the transaction occurred depended upon whether or not that money had moved from purchaser to vendor. In terms of the financial aspect of the completion taking place, and upon exchange for a properly completed TR1.
But focusing upon the latter,
Yes.
Mr. Kilvert knew that the only TR1 that apparently existed, well, there were 3 different versions of it, but that's immaterial for these
Yes.
purposes, was unwitnessed.
Yes. There isn't... We wouldn't be here
So
now if there were a
he
witness
didn't
search.
think that, he couldn't have thought that there had been completion
Well,
of conveyance.
my lord, could I just invite you to look at paragraph 23 of Mr. Kilvert's witness statement? Because it's better for him to say in his own language what he thought the position was, rather than for me to paraphrase it.
But this is before he received the papers from FLP.
That is right, yes. But what he says is that from his review of the documents, it appeared to me that the sale transaction had quite possibly been completed in the sense of an exchange of money for a transfer, but not, of course, as followed as it should have been by registration. Now, my lord's quite right. There was no document that ever came to light to suggest that a properly executed transfer had been produced, but
I'm sorry, he's stating there his state of mind as at 19th June 2009, and that evidence is supported by his attendance notes
Yes.
of that date. I'm sorry, it's slightly later in June. It's actually 31st July 2009. I misspoke, but it doesn't matter
Might I just get some water?
because what he goes on to say in paragraph 24 is that he got the papers from FLP,
Yes.
and that has included the 3 TR1s, all signatures unwitnessed, as he says in sub-paragraph little Roman 6.
Yes.
And so at that point in time, he knew that there had been no effective completion of the TR1.
My lord, I see that. The point I want to draw out from all of this, though, is that in terms of what harm might have been done, and I'll come back to this point, because it's a distinct point, a little later, is that there could have been there could have been a payment of money, at least on the solicitor's records, as between the bank and FLP acting in its capacity as solicitor for Mr Ul Haq. Now, if
so in a normal conveyancing transaction, you have different solicitors.
Yes.
And at some point, money moves from the vendor, the purchaser solicitors to the vendor solicitors.
It does.
But it's usually, I'm afraid I don't know the mechanics of this, but you normally only pay over the money if you get your TR1.
My lord, the whole way that conveyancing is structured now is that the solicitor for the vendor receives the purchase monies against an undertaking to forward the completed TR1. So it's not as it would have been at an old-fashioned completion meeting.
You don't sit across the table and hand a bag of gold over for the conveyance. But you do it by post, but
Yes.
the money goes from the purchaser's solicitors to the vendor solicitors.
Yes.
Who is it held for at that stage? Is it still held for the purchaser until the transaction is...
Until completion.
Until the TR1 is released? I mean, until what?
The completion occurs when there is that exchange of... there's a case called Lloyd's Bank and Udin, decided about 10 years ago in the Court of Appeal, which held that completion is the exchange of genuine documents for money.
Yes.
Now, of course, with postal completion, what will happen is that the purchaser's solicitor provides, usually in advance of completion, the purchase money to the vendor's solicitor.
Who at that point still holds it to the order of the purchaser.
Exactly.
Or purchaser solicitor.
And at the moment when completion takes place, he's under an obligation to remit the TR1 to the purchaser's solicitor. I think it says within 20... I can't remember now whether it says immediately or within 24 hours.
But presumably, the vendor solicitor will only give that undertaking, assuming the vendor solicitor is acting honestly, with an executed TR1 in his hands.
Yes. But he should... it's his problem if he gives the undertaking without it in his hand.
The truth is, we don't know at all, because it's the same solicitor acting, we don't really have this.
Yes.
So we don't know at all at what point, if ever, the money ceased to be held by FLP, is it?
Yes.
For the purchase for Mr. Atarian and became held for Mr. Ul Haq. We don't. Do you have a case as to whose money it was when it was stolen?
Well, my lord, we had not, in our case, pleaded that had definitely happened. What we recognised is that the case that was being pleaded against us, and it was asserted on this basis, was the loss of an unpaid vendor's lien. If Mr Ul Haq's solicitors had received the money or allocated the money to Mr Ul Haq, he would be treated as having received the money.
So it was his money that was stolen?
It would be his money that was stolen, and his vendor's lien would have been extinguished. Because once he's been paid, he's got no claim as an unpaid vendor.
I understand that.
Now, it wasn't we who asserted that there had been redemption and therefore completion.
Yeah.
It was Mr Brown in his...
You can't redeem the mortgage unless you've had the money. So
Exactly.
yes.
So it was Mr Ul Haq's lawyers who asserted in the re-amended pleading that this had happened, which is why we said that is destructive of your case.
Yeah.
Now,
Isn't this all a bit artificial? Because in truth, nobody knows what happened.
well, it depends on what status one affords to the internal records maintained by FLP.
Yeah.
At one stage, the legal advisors for Mr Ul Haq, or his estate rather, asserted that those records showed that there had been redemption ergo completion of the transaction. If that's right, case ends. But the point was taken, well, we haven't actually amended in accordance with our re-amended pleading, so we won't rely on that part of the case anymore.
Well, we can well understand why you say the history is unsatisfactory so far as the way this matter is dealt with, and that may be something that redounds in costs hereafter. But am I right in understanding that for today's purposes you accept that it cannot be determined for sufficient certainty for summary judgment purposes whether the mortgage was redeemed and therefore whose money was stolen?
My lord, I do accept that unequivocally, and we've explained why in the skeleton argument.
Yeah.
The argument was run before the judge. We, not just me, but counsel for other parties made the same submission. This is in the re-amended pleading. Whether or not it's been formally re-amended, you should take that as being the correct assertions to what happened. And the judge didn't accept that. He said, it hasn't been amended. I'm going to deal with this on the basis of the previous edition of the pleading. We haven't said he was wrong about that. We're stuck with it. So I accept that. But what I do say is that when one sees the importance of this point, it is extraordinarily unsatisfactory to say, well, the case now should hone in on this point, unpleaded throughout, and be decided potentially on it. It's simply not the way cases in the High Court should proceed, certainly not by the time they reach the Court of Appeal.
I'm deeply sympathetic to that submission, but nevertheless, as you will appreciate, the question for this court is whether summary judgment was rightly entered, and if there is a viable claim, then it was not rightly entered, albeit, as I say, that there may well be consequences as a result of the way in which the point has emerged so late.
My lord, I would say in relation to that one now has, when looking at what is meant by the overriding objective in terms of dealing with cases justly, to take into account other considerations as well. Many people would regret moving on from the late 19th century formulations about anything which
you
could
can
be
be compensated for in costs.
Precisely.
Exactly.
Many of us perhaps sad to see that go, but that's water under the bridge now. We are now operating under a system of rules which expect people to get their cases in order when major applications are dealt with. And there must come a point at which it becomes too late, and I would submit now it is too late, to fasten upon the AP1 as the whole basis of the existence of a duty of care when that has not been the position hitherto. So I've said what I want to say about that development of the history of the case, but it is in my submission important. Can I now come to the facts of the case, which in my submission feed very importantly into duty? First of all, we submit that there is no realistic prospect at all in this case of its ever being established that Mr. Kilvert was told that there was a challenge to the genuineness of the signature on the document in question. I probably don't need to take my lords back to the documents themselves, but the position is this. As to the conversation that took place, it is said in the spring of 2010, there is no documentary record at all to support what is said on behalf of the claimant. Mr. Kilvert, we would invite the court to find, is a sufficiently careful note-taker to have noted on his substantial file a conversation that he had with Mr Ul Haq about getting a TR1 executed in going to Mr Can's office for that purpose. There's nothing to support the pleaded case about that spring conversation at all. What we do know is that in the summer of 2010, Mr Kilvert sent a letter to Mr Ul Haq saying he had the completed transfer form and that it had been signed and witnessed, uncontradicted. We move on to the spring of 2011, and there was a conversation, and Mr Kilvert prepared an attendance note. Now, in the real world, there are two possibilities here, I would submit. First, Mr Kilvert was told there is a challenge to the genuineness of the signature. If that's the case, Mr Kilvert not only is lying in his witness statement when he says, at paragraph 2, I know of no reason why this case should go to trial. It means that Mr Kilvert is basically a crook. If he has put forward that witness statement and behaved as he did, if he was told what the claimant says. The other possibility, which we submit is the much more likely one, and indeed the only one that is credible, is that it wasn't mentioned. And that is why Mr Kilvert, within a day or so of that conversation taking place, repeated what he had said the previous year and said, you have signed this document and it was witnessed by a solicitor. There was every opportunity to challenge, there was no challenge. Now, against that background, we submit that there is no material that could possibly overcome it at trial. Mr Brands accepted that on the material that is presently available. But there is no basis for believing that there is any such material. We have now had 2 applications before Masters, an appeal to a High Court judge, and now we're in the Court of Appeal. And we still have no idea where this supposed rescue of the claimant's case might come from. Nobody can identify any material at all. I ask rhetorically, is it seriously believed on the claimant's side that there may be a file note prepared by Mr Kilvert to the effect that I was told this, but I am going not to disclose it? That's totally incompatible with what he said in paragraph 2 of his witness statement. And I do prenate that this is a case framed only in negligence. There isn't a hint of fraud. There isn't a hint of professional misconduct. It's framed in negligence, and negligence alone, which is material. And it has not been suggested, as the judge recorded, that Mr Kilvert has in any way been dishonest or unprofessional. Now, against that background, what is the real prospect for the factual case that the claimant stands by? None. That, in my submission, feeds in to the question of the duty of care. Can I go straight to Dreambar? P&P, Dreambar. Two cases involving conveyancing transactions. They were more complicated cases in a sense than the one that my Lords are concerned with today, because numerous different causes of action were canvassed and there were 2 defendants in both cases. The cases were only connected by legal themes which linked them together. They were also connected by the fact that counsel for solicitor defendants in both cases happened to be the same person. But what the cases had in common, which is relevant for today's purposes, is an allegation of negligence against a vendor's solicitor for releasing completion monies to a rogue in circumstances where it was foreseeable that if the vendor's solicitor did not take proper care in establishing the identity of the vendor client, such loss could be inflicted. So there were also, in those cases, allegations of breach of trust, of breach of warranty of authority, and so on. But it's the nature of the case that's significant for today's purposes. Despite the fact that it was eminently foreseeable that if the vendor's solicitors did not exercise proper care in breach of the anti-money laundering regulations, despite that fact, the Court of Appeal in both cases declined to find that a duty of care was established against the vendor's solicitors. Now, it's worth actually mentioning one other feature of those cases, because there is this overlap with the breach of trust claim. The solicitors in the Dreamvar case, who acted for the vendor, did not even think it was worth arguing on the breach of trust case that they should be granted relief for breach of trust on the basis that they had acted honestly and reasonably and ought fairly to be excused. They didn't pray Section 61 relief. It was that hopeless. Yet despite having so badly fallen short of what they should have done when judged by the standards of the money laundering regulations, no duty of care was established. It was expressly rejected by the Court of Appeal. Now, let me take that background and apply it to a submission which my friend has made in writing in this court. I don't think he articulated it this morning, but it's there in his written submission, emphasised in italics. That this case is different because it is concerned with a solicitor who may, by his own action, cause harm to another party. And I ask rhetorically, how does that differ from what happened in PNP and Dreambar? The solicitor for the vendors, in both those cases in the Court of Appeal, could inflict harm upon an innocent purchaser by their own actions, by releasing money without having carried out proper identity checks. There's no exception such as identified by my learned friend. But coming on to the analysis now, as I would like to do in the Dreamvar case, could I begin by inviting my lord to go to paragraph 74 in the judgment of Lord Justice Patten, who on this point commanded the support of all three members of the Court of Appeal in that case. What his lordship said at paragraph 74 was this: the imposition of liability and negligence towards a third party who is not the solicitor's client clearly requires something more than it being foreseeable by the solicitor that loss will be caused to the third party by a lack of care on the solicitor's part in carrying out whatever is the relevant task. Nor is it sufficient that the test of proximity is satisfied, whether by an actual assumption of responsibility or by the existence of a direct interest on the part of the third party, as in Dean and Allen and Watts, in the product of the solicitor's instructions. Now, let's just go back to the facts of this case, judged from the perspective of Mr. Kilvert. Mr. Kilvert's perception of the situation, if the court rejects any realism in the claimant's case, and finds it to be based, as we invite the court to find, that it is based upon Micawberism, if the court takes that step, then there was no foreseeable loss to Mr Ul Haq if the document were sent to the land registry and the transfer were registered, because judged from Mr Kilvert's perception, there was an unchallenged transfer which had been signed and witnessed. And I ask again rhetorically, where is the foreseeable loss? What is the foreseeable loss that underpins the duty? What duty, what fact should have prevented Mr Kilvert from doing what his clients asked him to do, and that is to register the transfer? There is no basis for it.
But the missing piece in the jigsaw was that he'd asked for evidence of identification and hadn't received it.
My lord, that's true, but it doesn't go to the question of whether he could see that there was a foreseeable loss, because he has spoken to Mr Ul Haq. He has told him twice in writing, I have a transfer which you have signed and which was witnessed before a solicitor, and it has gone unchallenged. Why should Mr Kilvert perceive a risk of loss? What foreseeable loss was there before him to justify upon him the imposition of a duty of care? In my submission, that is a piece of the jigsaw missing, fatally, in establishing the existence of a duty of care. May I also go back in terms of the analysis to the document itself, the AP form itself. My lords, could we begin at page 300 in the supplemental bundle? The document is a land registry document. It's an application to change the register. And what it says on page 302, confirmation of identity, is that when registering transfers, charges, leases and other dispositions of land, or giving effect to a discharge or release of a registered charge, land registry relies on the steps that conveyancers take where appropriate to verify the identity of their clients. These checks reduce the risk of property fraud. And then goes on to explain about the position where a person was not represented by a conveyancer, etc., that the land registry requires evidence of identity. And then we come on to the page that we've seen, 303. This document in my submission, or our submission, is analogous to the money laundering procedures in the Dream Bar case, PMP case. The money laundering regime, or the anti-money laundering regime, is not actionable at the suit of an injured party who parts with money because money laundering procedures have not been properly carried out. This form is not completed by the person lodging it, because the person lodging it is under a duty to the party on the opposite side of the transaction. In respect of the completion of this form is completed by the person lodging it in discharge of his duty to his client. In our submission, this document cannot, in the manner of completion, found a duty of care actionable at the suit of someone in Mr Ul Haq's position anymore when the injured buyers in P&P and Dreambar could found their actions upon the anti-money laundering regulations. May I go back fairly briefly to the authorities in terms of what is required to establish a duty of care. We threatened in our skeleton argument to wish to take my lords today through that passage in the judgment of Lord Wilson in NRAM, which analyses in some depth the cases that concern duties owed by solicitors to third parties.
Sorry, can I just come back to the submission you made a moment ago?
Yes, of course.
Which is obviously an important one. Can I just ask you about section 3.2 of the AP1?
Yes.
You've drawn attention to what's said in section 12, and I understand your submission about that. We've seen what's in section 3.13.1, but I'm interested just for the moment in what happens where someone's not represented by a conveyancer, and in particular what is said about evidence of identity at page 304 in the bundle.
Yes.
So it's where any transferor, landlord, transferee, tenant, borrower or lender listed in one was not represented by a conveyancer. So this is expressly requiring the provision of information where it's applicable that is not going to be just the relating to the client of the conveyancer completing the AP1.
Yes.
And it requires them, if this is applicable, to confirm that they are satisfied that sufficient steps have been taken to verify the identity of, and that they are the registered proprietor or have the right to be registered as the registered proprietor,
Yes.
and to enclose evidence of identity. So is it your submission that if that box is completed, nevertheless there is no duty of care in respect of the person in relation to whom it is completed?
My lord, yes. There may be a duty of care to the land registry. This document I submit is primarily for the protection of the land registry that can be landed in difficulty in terms of compensation liability if it registers and it proves not possible to rectify the register later. This document is to protect the land registry. It is not to protect the other party, any more than the money laundering regulations are there to protect purchasers. So that's the first submission. The second submission is this. Actually, and I apologise for not making this point before, there is a part of the history of this case which is highly material, and I'm very sorry I didn't mention it a few minutes ago when looking at this. The fact is, in this case, that Mr Ul Haq was represented by a solicitor at the time that the contract was exchanged. Now, today, although this isn't actually the pleaded case for Mr Ul Haq, today it's been confirmed that it's accepted by the claimant that there was an exchange of contracts. So I'm going to work on that basis despite what's in the pleading. If there was an exchange of contracts and the purchaser had a solicitor acting for him, as all the evidence pointed to at the time when Mr Kilvert was completing this document, that solicitor for the purchaser had a duty under the anti-money laundering regulations to establish his client's identity.
When you say purchaser, you mean vendor?
Vendor or purchaser, yes. the solicitors for the various parties involved owed a duty under the money laundering regulations enforceable by action other
To
than
be
a
sure,
negligence.
that's obviously correct, but why does that assist in circumstances where the foundation for the AP1 is the document that was purportedly executed in 2010?
Well, my lord, if one looks at page 304, the box that my lord read to me just a moment
It's the
ago.
transferor, that's
Yes.
to say the person executing the TR1
Yes,
that's being registered,
yes.
and that's the 2010 document.
My lord, yes. I confirm I am satisfied that sufficient steps have been taken to identify the identity of, if it were, the transferor.
Yes, but the reason why I asked the question is, I quite take your point that we can proceed for the present purposes on the basis that FLP were acting for Mr Ul Haq back in 2008 when contracts were
Yes.
exchanged. But the relevant transfer is the TR1 executed in 2010, and Mr Kilvert knew that FLP had not acted in relation to that document. Therefore, any assurance that FLP had in relation to the identity of their client in 2008 could not have been material. That, at any rate, is the argument against you.
But my lord, the identity of the person is the same. There is no dispute about this on the facts. Mr Ul Haq, the claimant, is the person who had...
It's the identity of the person who turned up and signed the TR1. That's what matters.
The transferor... I see my lord's point. The transferor should be the same person as the person who signed the contract.
Should be, indeed. That's the critical point in this case, isn't it?
Yes, I see my lord's point, but the Mr Ul Haq was dealing with Mr Kilvert on the basis that he was the contracting party back in 2008. And the information given to Mr Kilvert, and uncontradicted, was that it was Mr Ul Haq who had been to a solicitor and whose signature had been witnessed. So that, putting two and two together, one gets 4, not 5. The Mr Ul Haq who signed the contract was Mr Ul Haq who signed the transfer. And he, Mr Ul Haq, wasn't disputing it. I do apologise. Could I just refresh my water supply? Can I go back to the authorities and go to NRAM? Lord Wilson reviewed some 6 cases on the liability of solicitors to third parties. He began his analysis at paragraph 25. He mentioned Ross and Cornters, another wills case, and then he went on at 26 to look at the New Zealand decision in Allied Finance and Haddo. That was a case, unlike this one, where a solicitor told somebody who was going to be relying upon a security that the instrument was binding on the person who had executed it. They knew it wasn't binding because they weren't intended to become the owner of the yacht that was to be the subject of the security. Well, not surprisingly, it was found in that case as a liability. Very different from this case. It's a case of reliance and a case of a representation made by a solicitor as to something which he knew to be the case, and the other party did not know that was the case.
Yeah, the two that Mr Brown relied upon most strongly were Al-Kandari, which is dealt with in 28,
Yes.
and Connell, which is dealt with in 30.
Well, my lord, I will, in those circumstances, confine my observations to those two cases. Al-Kandari was a very different, very, very different case from this. Al-Kandari was concerned with an undertaking which had been given to the court for the express protection of another party, which would prevent children from being abducted to Kuwait. It was quite clearly given so that the court could rely upon it and the other party could rely upon it. And that was known to be the case, miles from this case. Connell. That was a case in which, prior to, I take the facts from Lord Wilson's summary, prior to marriage, the claimant wanted to enter into an agreement, the statutory effect of which would be to contract them out of the law's general provisions for the making of financial adjustments. Under one of the statutory requirements, the defendant, W's solicitor, certified that prior to her signing the agreement, he had explained its effect. Following separation, the judge found that hadn't been explained and held that the agreement was void. The Court of Appeal held it was highly arguable that in giving the certificate, the defendant owed a duty of care to the claimant, and the claim should not be struck out. And Mr Justice Thomas explained that the claimant had relied and had been expected by the defendant to rely on the certificate as a feature of the validity of the agreement, and that there had been the necessary assumption of responsibility towards him on the basis of the defendant, on the part of the defendant. Again, miles from this case, there is not any pleaded suggestion of any reliance on the part of Mr Ul Haq, on the part of anything done or to be done, or not to be done, on the part of Mr Kilvert. It's a missing ingredient. And another not pleaded feature, not pleaded in any way, and it's not even been suggested in argument, let alone supported by evidence that there was any reliance on any such thing. And I emphasise, I won't read it out, but could I just invite my lords to look at paragraph 27 very briefly. It's a Scottish case, a decision of the Lord Ordinary Lord Jauncey in the Outer House, Midland Bank and Cameron, which emphasises the importance of reliance. Ingredient number 3, the third party must have relied upon the advice or information as a matter for which the solicitor has assumed personal responsibility.
All these cases and the facts in NRAM itself are about the plaintiff or pursuer or claimant relying on something that a solicitor on the other side has said.
Yes.
And sometimes that can give rise to an assumption of responsibility, but usually it doesn't. And in the case before the House, it didn't, because although the solicitor had said something which was quite plainly untrue, it wasn't to be assumed that the bank would rely on it. The case you're facing is not put on that basis, as you've said. It's put on a different basis, which is that you can do things as a solicitor which can impact badly on other people. And it's that which is relied on to generate the duty of care. It's not a statement case. It's not a misrepresentation
No,
case.
it isn't.
And so I think the question is, in what circumstances can the fact you're acting as a solicitor for one party generate a duty to another party?
Well, that point was picked up in Dreambar in the judgment of Lord Justice Patton, where he grappled with that very problem. He took it up. He began to take it up at paragraph 74, which I took you to
Yes.
a few moments ago, in which I made the submission about foreseeability of harm being an essential ingredient, and my lords have my submission about that. But he took up the very point that my lord is probing at paragraph 75, when he mentioned NRAM and the importance of the assumption of responsibility. And then in paragraph 76, about 6 lines down, he said this: there will rarely be an actual conscious or voluntary assumption of responsibility, not least because the solicitor or other professional will have a client to whom he is contractually bound. But on the basis that the court is deciding whether to treat the defendant as having assumed a legal responsibility to the other party, non-client, for his actions, it will be necessary to balance the foreseeability that the third party will rely on the professional to perform their task in a competent manner against any other factors, which would make an imposition of liability unreasonable or unfair. So we have here again the significance of the foreseeability that the third party will rely on the professional to perform their task.
I understand your emphasis on foreseeability, and as you say, we've got your submission on that. But of course, one's got to be a little careful about reading too much into the word rely, because Mr. Brown's submission is that in the relevant sense, Mr. Ul Haq did rely upon Mr. Kilvert because, so it is argued, Mr. Kilvert knew 2 things. Mr. Kilvert knew that Mr. Ul Haq was no longer represented by FLP, and he also knew that he, Mr. Kilvert, had not had evidence of identity. And therefore, the argument goes, Mr. Ul Haq was in effect relying upon Mr. Kilvert taking sufficient care in the way he filled in the AP1, knowing those 2 facts.
Well, my lord, he doesn't say that in his pleading.
I've got that point.
There isn't any suggestion from Mr. Ul Haq. Well, because Mr. Kilvert was a solicitor, I expected him to do certain things, and he let me down. He doesn't identify that feature. It doesn't figure in the case. It may figure in argument today for the first time, but it hasn't figured in the case. And sometimes, if people don't say things, it really does have important consequences, because some ingredients of a cause of action are so fundamental that they need to be said. They need to be supported. And if they're not, well, they're lacking, and the case is not deserving of being allowed to continue. And the point I would make in that context is this: the person who needs to say it is no longer with us. It won't do for a lawyer now to recast the case and put in those words when they didn't form part of the case described by Mr. Ul Haq himself. What is the basis upon which anybody can now plead Mr. Ul Haq relied upon Mr. Kilvert? It's missing.
Well, Mr. Brown is here on the instructions of the estate.
He is, indeed. But how is the estate in a position, unless there's material from Mr. Ul Haq, how is the estate a position to give those instructions? There is no witness statement. There is no hearsay statement. There is absolutely no material to support this suggested reliance.
I didn't understand the case to be put so much on reliance, but as I said, on the fact that what Mr Kilvert was instrumental in doing, which is putting forward the transfer for registration, had a potential to, and in fact did, damage Mr Ul Haq's interests, which doesn't seem to me to be a case that's dependent on reliance in the sense you've been using it at all. That was what I understood. Generated the duty, was said to generate the duty, was that what Mr Kilvert was doing was going to impact on Mr Ul Haq's legal rights.
Yes, my lord, I appreciate that. I was focusing on the part of the analysis in Lord Justice Patton's judgment which concentrates not so much on an actual assumption of responsibility, but an imposed assumption of responsibility. And even in that element, that alternative formulation, he attributes significance to reliance, not in the sense of relying on Mr Kilvert told me this and I relied on it, but in the sense of I relied upon Mr Kilvert to do his job as a solicitor.
Yes.
Not even that is suggested.
That's not, as I understand it, suggested.
No. And so I submit that that important ingredient of the build-up to the foundation of a duty of care is missing. Of course, there are other factors, and I'm coming to those now, if I may. Unless I can assist further in relation to that, I think my lords have my submissions on paragraph 76.
Well, can I ask you this, just before you move on? I think your submission is, your submission is, that when filling in the AP1, Mr Kilvert's not acting for all the parties to a transaction, he's only acting for the bank.
Yes.
Is it necessary for us to decide or consider why the identity is sought? Your submission is it's to protect the land registry from paying out under the indemnity, and I can see that that's a very, from the land registry point of view, that's very significant. But could it not also be said that it's in the public interest that the registered proprietors of land do not have their land stolen from them, and that the land registry's requirements to see that doesn't do identity checks itself, but to be satisfied that identity checks have taken place is for the benefit of those registered proprietors as well?
My lord, that could be said, but it wasn't. With respect, it doesn't take the case away from the analogy with anti-money laundering.
Yes, no, I
because
see
it's
that.
in the public interest for money not to be stolen from people. There's a whole industry dealing with anti-money laundering. An industry running into billions of pounds a year today with accountants, solicitors, and so on. So the fact that something is in the public interest because it protects innocent people from becoming victims of crime isn't enough to justify the imposition of a duty of care.
Because otherwise it would have imposed on the vendor solicitors a duty to the purchasers, who are the ones who lost out in Dream Park because the money was paid over, but they never got their title.
Exactly. And it's always a question of for whose benefit is the duty imposed, and to whom is the person in breach accountable. It's not good enough just to say, well, there was a breach.
Oh, no, that I understand. But when Lord Justice Patton talks about it being a legal construct, picking up what Lord Wilson said, and there's rarely a voluntary assumption, but the court decides whether to treat it. I think that's what it comes down to. Should the court decide to treat Mr Kilvert as having assumed responsibility to Mr Ul Haq, the true registered proprietor, when filling in the AP1? That's what it comes down to.
My lord, I respectfully agree, but the submission I make is that when one looks at that question, one of the factors that the court has to weigh is what foreseeable loss was there, and was there a foreseeable loss to Mr Ul Haq? And I submit, for reasons I'm not going to bore the court with again, no, there wasn't. So that ingredient's missing. The next matter that's of some import, Lord Justice Patten then went on to review other things as well. He said at 77, it seems to me there are a number of such factors to be considered in the present case. As the judge himself observed, there was clearly no actual assumption of responsibility by OWC, those were the solicitors in P&P, or by Winkworth, the estate agents in P&P. In this case, both sets of professionals were instructed to act for the vendor on an arm's length sale of the property. The same goes for the sale in the Dream Bar case. In both cases, the purchasers instructed their own solicitors, who were free to raise any inquiries they wished, and could, at least in theory, have sought some undertaking from the vendor's solicitors that any necessary AML...
Isn't what's said in paragraph 78 the crunch? Because in 78, he says, the MLR do not, as I've said, create a statutory duty which gives rise to cause of action suited claimants.
Yes.
That's because the statutory duty was imposed for the benefit of society at large, not for any particular class of persons such as the purchasers in these cases, who are likely to suffer loss if the vendor turns out to be an imposter.
Yes.
In part because this was the principal purpose of the MLR to deter money laundering terrorism rather than to combat identity fraud. So the argument against you is that box 13 on the AP1 is distinguishable precisely because it is for the benefit of a particular class of persons, in particular transferors, and it is there to combat identity fraud.
My lord, it's more narrowly focused, I have to recognise that. My lord, if I may, I'd just like to go back to the conclusion of paragraph 77, because there, Lord Justice Patten's observations coincide with the submissions I was making a moment ago. The highest it can be put is that the defendants in both actions should have realised that the purchasers would rely on them to carry out the AML checks in a full and competent way. And I submit that that is as high as it could possibly be put in this case, even though it's not asserted. But I see my lord's point that the MLR regulations are more widely cast than the form in this case. Now, moving on to 79, because this is another factor. If one adopts the incremental approach, starting from the general rule in granulato, a solicitor in a conveyancing transaction doesn't normally owe a duty of care to anyone but his own client, then it seems that there is no material distinction between cases like White and Jones and Dean and Allen and Watts, and the situation in the two present appeals. In both those cases, the instructions which the solicitor received were intended to benefit both the solicitor's own client and the third party. For that reason, there was no conflict of interest between the two parties and an expectation that the arrangements the solicitor was instructed to put in hand would inure for their mutual benefit. The third party was in as proximate a position to the solicitor as he would have been had he been their client. It was what is referred to in some of the cases as a situation equivalent to contract. Well, that is a feature absent from this case.
Well, you're quite right about that. But can I ask you this question? Would it not be in the interests of the bank to ensure that the AP1 was filled in with reasonable care so far as box 13 was concerned? Why would not the bank's interest and Mr Ul Haq's interest aligned so far as that particular point was concerned?
My lord, it was in the bank's interest for the security to be registered, because otherwise they had no security for their money. It was Mr Ul Haq was in a different situation. It might not have been in his interests for the transfer to be registered if it was a forgery. Well, it wouldn't have been in his interest for it to be registered if it was a
Well, it
forgery.
wouldn't be in the bank's interest for a forgery to be registered, would it?
Well, there's always a risk that any document may be a forgery. But I do apologise, I'm going to have to come back to this point again. From Mr Kilvert's perspective, he had no reason to doubt, on the factual analysis for which I'm submitting, that the document was a forgery. Quite the reverse. So there wasn't any conflict that affected the bank that would have caused the bank, I'm sorry, there wouldn't have been any concern that would have affected the bank that would have caused the bank to say, don't go ahead. The bank wanted to go ahead with the registration. It was they who instructed Mr Kilvert to register. And if one stands back again, looks at the reality of the situation, if the bank had asked Mr Kilvert, well, what do you think? Let's look at the material upon which we can make a decision. It's the same old material. It's Mr Kilvert saying, well, I've got this document, it's witnessed by a solicitor, and I've no reason to think, and I've spoken to Mr Ul Haq, I've no reason to think it's challenged. So in those circumstances, it's in the bank's interest for the security to be registered. Without reading on, because I'm sure my lords are familiar with the point that I'm about to come to, and I don't think I need to go to authority for it, and the judge developed this at some length. A classic contraindication for the existence of a duty of care is that there are rival interests and a conflict between parties. And in those circumstances, the professional retained by one will not owe a duty to somebody on the other side. In just the same way as in one of the cases that Lord Wilson reviewed, the Jane case, a party owes no duty of care to a person on the other side of litigation. Here we have a land transaction. It is in the interest of the solicitor's client for the transaction to be registered on the material available to the solicitor, and perhaps not in the interests of the party on the other side. It's a conflict of interests. And that's it. Once that's identified, and it's a genuine conflict of interests, there's no room for a duty of care.
Can that be right in view of the reasoning in PMP? I take your point. Obviously, in circumstances where there's a conflict of interest, that's a pointer against it. But can you go so far as to say it's completely negatives it? I mean, look, for example, what Lord Justice Patten says in paragraph 81. He doesn't rest his decision upon the fact that there's a conflict of interest because the solicitors were acting for clients on one side of the transaction. On the contrary, he goes on and says, for example, at the top of page 313 of the report, more particularly, there's nothing in the way these transactions were conducted which made it objectively reasonable to assume that AML checks would be complete and the defendants should be legally accountable to the purchasers for the consequences. Find it difficult to see how the imposition of such liability can be justified. In this case, where it's common ground, Parliament did not intend to create a breach of the MLR to create a private law cause of action in favour of the claimants. So it's not merely the fact that the purchasers were on the other side of the transaction. It was also the fact that the particular failure that was being relied upon, which was one where it was for the protection of society at large, and particularly anti-terrorism and so on, wasn't specifically for this class, and there was no private law cause of action.
My Lord, I recognise that, but could I just ask my Lord also to look at paragraph 80, in which his Lordship said, but in the transactions with which we are concerned, the vendor and the purchasers were very much at arm's length, and their solicitors owed no duties to anyone but their client when acting in relation to the sales.
to be sure. So it's a pointer against.
It's
But is
a
it
strong
conclusive?
contract. I think I overstated. I apologise. I overstated the situation. Conflict may not be an absolute bar, but it's a pointer, and a strong one.
Yes. Thank you.
So we have the lack of an ingredient of foreseeability, quite the reverse. The document reasonably would have appeared genuine to anybody in Mr Gilbert's position. We have a conflict of interests as well, for reasons I've described already. Why? I come back to this critical question. Why should Mr Gilbert have advised his client not to register? Did he have any doubt? Did he have any reasonable grounds for doubt? No. Did he have any reason to believe there was going to be loss? No. Would it be to the disadvantage of his clients on that analysis not to register? Yes. In my submission, and one factors in all of these things, and the absence of others, this is not a case where a duty of care could reasonably be imposed, because this is a construct case. The factors are against it, and the absence of other factors are against it. And I pray and aid where I started. And the way in which this has been developed is grossly unsatisfactory and ought not to found a last-minute reprieve on the grounds that are now before the court, which in themselves, in my submission, don't justify the salvation of the case. Might I just see if those behind me wish me to make any further points? My Lord Justice Nugee asked about conveyancing arrangements. Mr Dodge points out that those are actually fully described in paragraph 83 of Lord Justice Patton's judgment in Greenparth.
Yes, he deals with a 2011 edition of the code, which
Yes.
is presumably much in the same form as it was at the time of these transactions. We don't know precisely what it was like in 2008, but
it was the
Must have been quite similar to
Quite
2010.
similar.
yes, it was the edition of the code which was very similar in wording to that which was then
it
enforced.
explains all the mechanics about the undertakings on
it
each side
does.
and so on.
The crucial features were the same. There were undertakings from solicitors, and it was the undertakings from solicitors which ultimately caused them to be liable. And of course, the rules of the trusts applicable.
Yes.
The code has, as my lord probably knows, been changed again since, expressly in the light of Greenparth, because it now makes it absolutely clear that the solicitor is warranting that he is that he has the authority of the actual owner of the property.
Rather than just of his client.
Yes.
Yes. I'm conscious of the fact you said earlier that we can't resolve whose money was stolen. But just looking at the code, the vendor solicitors should not have released the money to their client unless they were in possession of not only a TR1, but also a discharge from the vendor's bank, because otherwise the purchaser doesn't get a good title.
The conveyancing practice, I think, has remained uniform in this respect. So far as discharge from a lender is concerned, the vendor's solicitor needs the authority of the bank to receive the redemption monies.
Yes.
That's good enough, because if he receives, once he receives those monies as agent of the bank is bound.
So maybe it wasn't Mr Ul Haq's money that was stolen, but the bank's money that was stolen.
It could be the bank's money. The money will go, when the money is released by the bank, it goes to the vendor's solicitor to hold initially for the bank. He then notionally pays it across to the...
So it initially
So
goes
when-
to the purchaser's solicitor.
when-
It
precisely,
transfers
yes.
it to the vendor's solicitor, who holds it for the
Yes.
purchaser's solicitor until completion. And on completion, he releases it in part to his bank client and in part to his lay client.
Yes. It goes through various stages depending upon his role. And of course, what we certainly don't know for certain in this case, what the stages were that it went through. It was alleged that there had been a redemption, but as I conceded earlier, I'm not in a position to say it is definitely the case. And the judge rejected it anyway.
And it I think, doesn't affect the issues we have to
No,
decide.
it doesn't.
Yes.
Unless I can assist further.
Thank you very much.
I have one other question actually, which is that I had a bit of a discussion this morning about the duty of a solicitor to comply with the instructions of a client. And obviously, if the instructions of a client are to do something unlawful or illegal or improper, then the solicitor's not under duty to comply. In fact, she's under duty not to comply with them. But in this case, the instructions are to register the transfer. Does that mean that as long as he believes the transfer to be genuine, he has no reason not to proceed with it? I mean, how does it?
Well, my lord, if the solicitor believes, let's take it a nice simple example to begin with. If the solicitor believes that the document is a forgery, clearly he must not register the
Has he
document.
been party to a conspiracy
Yes.
to defraud? Yes.
Absolutely, and he'd be uttering a forged instrument. It can't possibly be right. If, on the other hand, the solicitor has evidence sufficient to satisfy the burden of proof in a criminal case, that the document is genuine, then there can be no possible reason, because there is a fanciful possibility that it isn't genuine, for the solicitor not to register. Some cases are going to fall, indeed perhaps most cases, fall into the area somewhere in between. What is the material that there is to justify my not accepting the document?
Yeah.
Well, I'm not going to repeat the submissions I've made about that.
But just to complete that, I mean, as we were discussing earlier, I mean, in the present case, you'll correct me if I've got the facts wrong, but Mr. Kilvert didn't say to his client, the bank, although I have assigned TR1, I have not had the evidence of identity which I have requested. There is therefore a risk that actually, even though we have a signed document, it's been someone who is not the person who should have signed it. Do you wish me nevertheless to proceed?
My lord, there isn't any evidence to that effect, but I would submit that it isn't necessarily the case that a solicitor must give that kind of a warning, because a financial institution is likely to say to the solicitor making that, giving that sort of warning, well, what do you think? They're going to look to the solicitor for guidance. Do you think this is all right? And if the answer is yes, and Mr. Kilvert had no basis for saying no, the bank is going to say, well, why are you bothering to tell us this? It's a bit like the surgeon who has to wonder about whether he should give a warning to his patient of the risks of surgery.
And as to that, the trend of the modern law is strongly in favour of fully informed consent.
Yes, I appreciate that. But
And if we draw that analogy, then it might be said that the bank should be fully informed.
my lord, the bank isn't a complaining party here. The bank isn't saying Mr. Kilvert got it wrong. And I do submit that on the evidence for East Page, there really wasn't any basis for there to be alarm bells ringing.
Can I ask you one other question? If we were to take the view that the AP1 allegation is not currently pleaded, and it would be necessary to amend to plead it, would that be something that you would have a limitation objection to, or would you accept that it arose out of substantially the same facts? Or would you want to reserve your position unless and until we got to that stage?
I think we'd need to reserve our position on it, my lord, because we haven't even seen a formulation of the pleading.
Well, that's fair enough.
And so, I mean, prima facie, well, it is outside the limitation period. It's a question of how closely it's connected with the facts that are already pleaded. But I'm sorry, I can't be more definitive.
Well, that's entirely fair. Thank you.
Yes.
Can I start with a direct response to the suggestion that there is a new point in this appeal by reference to the AP1 form? There is no new point. I have been making the arguments in respect of the AP1 form throughout this response to the strikeout allegation. They are dealt with by the judge in paragraph 111 of the judgment. Nothing I have said to this court was not said below. So this is not new. It has not come out in the course of argument today. The respondent, I think, has perhaps jumped on a point which the court has suggested, but I categorically reject, refute, disagree with the suggestion that I have said anything that is in any way different from the arguments that I have run below. The point about the draft amended particulars of claim is this: that arose after we first went through the documents before the Master Clerk over 2 days, and I made all of the same points leading up to the AP1 form. And it is effectively those submissions that triggered the suggestion or the request that they be better and properly particularised in the draft amended particulars of claim. I accepted that invitation. I appreciate the point the court has raised with me as to whether that needs to be pleaded out further. I'm not going to say any more about that. I say it is there on the face of the pleading. But these arguments have been run consistently from the very beginning. It's been my case that the AP1 is the conclusion of a series of events which all need to be considered. Partly to respond to some of the points the respondents made now, this case isn't all about the AP1. The rights or wrongs of the decision on the part of Mr Kilvert to submit that form need to be considered by reference to what he knew at the time. So to some extent it is about his particular state of mind and what have just been described as alarm bells. So if the alarm bells were ringing because of what Mr Kilvert already knows and what he knows that he doesn't know, the known unknowns, were such that he should have held hard at that time and said, can I properly submit this form at all? Point one. Moreover, can I do it in this particular way? Now, point two is slightly artificial because the failure to exercise reasonable care necessarily assumes that he was careless as opposed to intentionally deciding to submit it in that way. But we say that the case is effectively built on those two parts, and it is the circumstances which Mr Kilvert knew of at the time which are significant, or at least a material part of the issue, when one considers the legal construct about assumption of responsibility, duty of care. So I appreciate this court, I detect, considers the AP1 form to be a particular feature of the case, but it is not the only feature. I've consistently said that it's the circumstances of this case and the cumulative effect of all of the events that ultimately give rise to the assumption of responsibility. Very briefly on that amended particulars of claim, and I have received trenchant criticism and I have broad shoulders, I have no quarrel with that whatsoever. That document was seeking to do two things, because what became apparent from a careful review of the exhibit to Mr Kilvert's witness statement was this possibility, which had never previously been clear, that there had been redemption prior to the fraud. As my Lord Sir Christopher Floyd put it, it's all rather artificial. We just don't know. So the respondent says, aha, but your amended particulars of claim asserts in terms that there has been redemption and therefore your claim against Priest-Page fails. That would be true if that had happened. But as, again, I have consistently said throughout this litigation, I don't know what has happened because I don't have the FLP ledger, amongst other documents, which would allow me to say whether redemption has occurred or not. So I necessarily have got two cases which are necessarily inconsistent with each other. There's a possibility that there has been a redemption prior to the theft, in which case my client has not in fact been defrauded in the first fraud, or there hasn't been redemption, in which case he does have his claims against the seventh defendant.
That sounds more like one case than two.
My lord, one case.
That sounds like one case rather than two, because if the mortgage has been redeemed, you don't have a case.
If mortgage, I don't have a case against the solicitor,
Yeah.
but I do have a case against the bank who's looking to enforce that mortgage against my client, and indeed has a possession order on the back of it.
Yeah, fine.
So this is the difficulty, and this is why all the defendants say to me separately, well, which is it to be? Do you advance your claim against us or not? Which I say, well, I don't know because nobody's given me disclosure. What I do know, though, is that it's one of those two alternatives. And the respondent accepts that. They say it's one of those two alternatives as well. We then have a digression occupying a lot of court time about what I do with my statement of truth, etc. I say, well, you know, I can't plead in certain terms that there has been redemption. I'm in this slightly unusual and possibly invidious position where I've got to say, well, it's either case A or case B. It depends.
I don't see why that's a problem. There's authority establishing that it's permissible to plead alternative inconsistent cases.
Well, I agree, and that's the point that I have said. But what is then said against me is that your draft amended particulars of claim, which were in fact intended really just to particularise the assumption of responsibility, didn't deal with this possibility that redemption has not happened. They say redemption has happened, and I accept that. And this is a point that the respondent relies on. They say, we pointed out to you the consequences of that redemption argument for your claim against the seventh defendant, and they are absolutely right. I accept that. I'm not arguing anything that's legally non-recognisable. But my answer to that is, well, it's perfectly obvious that we just don't know. So I just need to plead inconsistent cases and have a suitably amended statement of case that deals with all of that. It's come to my attention, actually, I personally didn't know this issue may well be before the judge. In fact, at the moment, so Mr Justice Edwin Johnson is dealing with this issue in terms of the outstanding claims against the bank. I think as we speak, possibly even today, I'm not entirely certain what the position is in respect of all of that. I'm not instructed on that. I'm dealing with this. So there is an outstanding aspect of this about how that alternative case is to be pursued, if at all. And the judge expressed some real scepticism about that. But for the respondent to start on that today and say, well, that's the problem here, because you, Mr Brown, have not pushed your amendment on the draft amended particulars of claim for the reason I've just given, namely it doesn't cater for this inconsistent case issue, means that you can't then look at my pleading of assumption of responsibility as casting any light on how the case would be put if we ever get to the stage of the CMC, and if I ever get a proper opportunity to properly plead. Which I say, well, not right, because you understand the arguments we're making. The draft amended particulars of claim are indicative of the case that we wish to run in respect of assumption of responsibility. Because the previous version of the pleading, not only does it use old-fashioned notions, Caparo notions of how the duty arises, as opposed to representing the more modern statement of principles, it doesn't actually also properly set out all of the various factors leading up to and including the submission of the AP1, which is what it was intended to do. Now, maybe some further tweaks are required, but it is no more than that, if indeed that is required. And a degree of latitude respectfully should be shown in terms of the content of that pleading document. There can be no doubt that this respondent understands and has always understood the entirety of the case that we were putting, and there is no new point there. On the substance then, really a small number of points, and perhaps the one that's repeated the most is that Mr Kilvert's position, based on what he knows, is that there's no foreseeable loss. So a nice point potentially to win on duty of care. I do say though that is something that requires proper consideration of what Mr Kilvert did in fact know when it came to the time of submission of the document. And this is why I talked the court through all of the documents in some detail. Because yes, he has received certain information, including from Mr Haq, about the previous transaction, but it's clear from the face of the documents, and indeed his own witness statement, that he is in a position of uncertainty as to whether indeed Mr Haq was a willing participant to either transaction. So would he in fact be in a position today whereby he would be consenting to regularisation of the original sale? Because he's not obliged to do that. And he could wait for Mr Atarian to seek specific performance or something of that nature. It's not the case that he can confidently assume that as of the relevant date in 2010, Mr Haq does wish for that earlier transaction to be perfected, regularised, whatever language one wants to use. So he knows that there's considerable uncertainty in terms of Mr Haq's general position regarding that earlier transaction. That is point one. And he also knows in 2010 that there is considerable doubt, or at least some doubt, as to whether he has signed the TR1, the identity point. So this is what distinguishes the case from the ordinary run of cases.
Why do you say that he knows there's some doubt whether he signed the TR1?
Because he says so. In the final notes that I've taken the court through, he says, I need to approach this case with some care because of its history. That must mean that he is saying to himself, this might not be as it appears. So an ordinary case, ordinary files that arise, the solicitor would have no reason to think that they are anything other than how they present. But that's not what his own final notes say in this case. He knows that it might not be an ordinary case, not least because it arises out of an earlier fraud. At one stage he knows that Mr Atarian is a possible fraudster, so he knows he's possibly dealing with the fraudster. He's not dealing with Mr Atarian's solicitors, he's dealing with him directly. He's sending the documents to him, giving him the instructions as to what would need to be done. And this is why the language of red flags, alarm bells, etc. becomes relevant, because there are factors and circumstances which suggest that he does appreciate here that it's not just the inherent risk of fraud in a conveyancing transaction, it is an actual risk of fraud in the particular transaction. The court asked then the respondent, what is the purpose of the AP1, and in particular page 304, whether the various boxes are intended to protect anyone other than the land registry. might it in fact be arguable that that form is designed in a way to protect society as opposed to just the land registry? Because it is in this...
Well, more specifically, transferors who are specifically mentioned.
Yes, quite my lord. So more specifically, transferors who are specifically mentioned, transferees are also specifically mentioned. Why is it not the case, at least arguably, that in fact the legal purpose of that document is to ensure a reasonable level of protection, knowing that one can never fully protect, but a reasonable level of protection in the legal mechanics that surround the process of property transfer. Those being serious and important legal rights in a sector which is known to be susceptible to fraud. The respondent says no. In absolute terms, you can determine on a summary basis that the document is only for the interest of the land registry, not the named parties or indeed society. And I say that that is a startling opposition. It might be right, but it's not right to the summary judgment threshold. Indeed, my submission will be that it's plainly wrong.
I don't think it's enough to establish it's for the benefit of society generally. You have to show that it's for the benefit of the transferor named on the transfer, the true registered proprietor.
Yes, my lord is right in terms of what I need to show. Legally, I need to show that it is for the benefit of the named party. So the fact that it probably does have benefits to society because we all have interests in lawful transactions. It's not going to get me home on personal assumption of responsibility to Mr Ul Haq. I'm simply answering the court's question. Well, who is designed to benefit? Is it really the case that it's just a land registry? So we say that that is wrong. Then the debate about reliance, my Lord Justice Nugee says, or indicates, well, it's not a reliance case. And one has to bear in mind, the authorities talk of a legal construct here. This is a set of facts in which the law imposes liability. There is no specific, there's certainly no contract, we know that. There's no direct statement, we know that too. How then does the language of reliance assist? And my Lord Justice Arnold, as well, in a sense, it arises because when the form is completed, it is obvious that the named third parties are going to be impacted, and it's reliance in that sense. I mean, take an example where there's simply no contact whatsoever between the putative vendor and the solicitor. So just leave aside whatever did or didn't happen between Mr Ul Haq and Mr Kilvert in this case. So what if there were a case when a vendor simply receives out of the blue some form of confirmation that his property has been transferred away from him without his knowledge? And the reason that that has been done is because the solicitor has submitted the AP1 document in the way that he has here, namely asserting that the vendor is a represented person when he is not. Now, there's no factual relationship at all between the person whose rights have been overridden as a result of that transaction. But why would the court not construct the necessary proximity and liability in those circumstances? Perfectly obvious when the solicitor comes to complete the form that that is a consequence of doing it carelessly. So the points that my client is dead, he can't say that he actually positively made arrangements on the back of this, they are misconceived in answer to this case, because they don't engage with the policy of the law and what the policy of the law is trying to achieve here, which is dealing with different factual circumstances where, on a multifactorial approach with a proper understanding of the facts, legal policy fixes the solicitor with liability. That is what this comes down to, and that is what P&P says.
Yeah, it's allocation of risk.
It's allocation of risk, yeah. So one balances the indicators, the conventional arm's length position, that is plainly a factor which goes on against there being a duty, whether it's adversarial or not. They're factors that all point against it, but they are no more than that. They're only factors, they're not decisive. And the error of both judges below was basically to say that they are decisive on these facts, and they plainly aren't. Because it's always going to be possible there to be a sufficiently compelling countervailing factor, state the reliance on solicitors doing their job carefully, the particular circumstances of named individuals within the relevant legal documents and how their rights might be impacted. And the law has to decide whether on those particular circumstances, in fact, the balance shifts, knowing that that will be an exceptional case. And that's where the money laundering example is actually illustrative in my favour, because P&P is itself a careful consideration of the balance of risk in an arm's length conveyancing transaction between represented parties who are consenting to the transaction. So the policy factors in P&P come down firmly in favour of no assumption of responsibility, the reasons that the Court of Appeal gives. But at least it's carried out that exercise in that case. Here, the court hasn't. We've never had that. But the fact that in P&P, all of the factors, arm's length, representation, etc., point against it tells you nothing about this situation when you have somebody who's not a willing participant to the transaction, is not represented by a solicitor, something that's very significantly against his legal interests, to which there are other background indicators which require to be properly and carefully considered by the solicitor. So this one didn't take you to the judgment. I've only taken you to it briefly, but that really is the cardinal error that has been made at both stages below, to not carry out this exercise against a proper factual footing, and simply to make an assumption that absence of a retainer is dispositive just doesn't meet our case, never has. So I do respectfully say it would be wrong to suggest that this isn't any new point at all. It is not. We are regrettably here many years after we should have been here, not for any fault of my client. We didn't ask to be subject to this application for summary judgment 3 or 4 years ago. We've resisted it and failed. We waited some time for an appeal and were unsuccessful. The delay and the cost of those appeals is not something that properly sits at the door of my client. She has only wanted the opportunity to progress this case. And it is right that she does that on a proper finding and proper conclusions of the law, but we do not have that, the reasons that I have given. My Lord, unless I can assist the court further, those are our replies.
No, thank you both for your most interesting submissions. You've given us a lot to think about, so we will reserve our judgment and hand them down in what is now the usual way. That is to say, it will be a remote hand down only with no attendance. You will get drafts of the judgments in advance under embargo, and I hope everybody in court now understands, following the General Council of Wales case, that the embargo must be strictly observed and that there will be serious consequences if it is not. The purpose of distributing the drafts is so as you can correct typographical errors and any obvious misapprehensions of factual matters, transpositions of names and that kind of thing, not to re-argue the case. If you can agree a consequential order at that stage, please do so. If there are items that can't be agreed, please put in brief written submissions.